Hello, good afternoon, everyone.
Good afternoon, ma.
Yeah, sorry for the glitch that's, I noticed by the time I was coming in
Good afternoon, ma'am.
minutes to 4, or yeah, to 4, I could not gain entrance, so we have to go through some other means. But thank God we are together again. Thank God for the new class, for another week. Okay, so who can remind us where we stopped last week? I want you to use the chat box. Remember, our chat box is where we use. That is where you can be heard. Who can remind me? Really? I'm saying offer. I'm saying quasi. Please, if you don't know it, do not just say anything.
Can I even look my own?
Someone said we ended our classification of contracts. Really? Oh, yeah. Really? Have we not started elements of contracts? That means those are same classification. Are you sure you were in our last class? Did you see the reason why our impromptu test is very important? That some people are not here. And we even have some that they would have their systems on, but then they are not in class. Okay. Let me then go to offer. Okay. I think while trying to explain offer, I think I've given you the case of Kale versus Carbolic Snowball. The essence of that case was to just let us know that when an offer is made, it can be made to specific set of people and not to the whole world. There are some offers that are made to the whole world. Some are made to specific people. Looking at this Kali versus Carbolic Snowball, if you don't buy their product and test it, then what they had offered to give, or what makes up the contract, or what would have enabled them to give them the promise would not have arisen. You understand? So we also have in cases of when banks or when companies, when they do adverts to the world, to people that they want to sell their shares. In that case, such offer is made to the world. Anybody can actually purchase or apply for that. So let's quickly move on. And like we mentioned the last week, that an offer is an expression of willingness to contract made with the intention that it shall be binding on the person making it as soon as it is accepted by the person to whom it is addressed. Okay? So you cannot just come today and make an offer and people accept the offer, then 2-3 days again, you come back and say no. When a person is making an offer, there should be an intention that this offer will be binding on them if the other person whom the offer was made to accepts the offer. All right. So let's then move to how may an offer be made. An offer can be made in several ways. All right. It can be made by writing. Bejide Precious, you can type whatever you want to tell me. Type it down so I can respond to it, okay? I hope by now I read all your chats. Okay, so I said that offer can be made by writing, by spoken word. It can also be made by just simple implied by simply by implication, by conduct, you know. So making an offer is not restricted to it just being written, to it being written or being spoken out. It can also be an implied offer. You know, you can imply from people's action or from law, from things. It can be implied by through statutes, you know, around you. Someone said, you don't need my material. I have, at the beginning of this class, I gave you an outline, and in the outline, I also indicate the textbooks that you can read. There are 3 of them there. The first one is Akonki, and there are 2 other ones. If you don't get that at Akonki, you can always get the other 2. All right, go to bookshops. I think there is a bookshop around Faculty of Law. You can also check there. You can check the school bookshop, you know. So I know even if I don't give you my material, a lot of you are taking a screenshot of it. I just want you to know that I didn't give this to you. So I mustn't see my material spreading everywhere, okay? You have textbooks. So if you get questions that is not within whatever you have snapped, whatever screenshot you have done, and is in the textbook, you cannot say, but this is not in our notes, okay? This is just like an highlight. And if you notice that anyways, that doesn't mean that if you didn't see whatever is, you don't come back and say, oh, but it's not in our notes, okay? It's not in our notes. Now, Bejide, I hope it's not that as you are doing this, you are not going online, scouting around to source and distracting my class. You guys have to be careful, okay? Now, your question here says that you can come later to withdraw. Of course, you can withdraw, but then remember, if we say it should be binding, if everybody just make an offer and people accept, and the 3rd day or whatever, people keep coming back to withdraw, the condition for withdrawal would be there. And the condition would be that the other party too agrees to it. Okay? Although, what can bring about is being a contract is when compensation has been made, consideration has been made. Okay? But then you cannot just be going around to give offer to people and then later you say you are not when they have accepted. Of course, you can withdraw, but then there will be condition attached to it. And because we are looking at integrity in business, so people don't turn business to their father's, to just do whatever they want. And that is why, and if you have read the textbook I gave to you, if not that you have been going online and whatever, if you have read the textbook, you will understand where this binding part of it comes in. Okay? All right, so let's try to distinguish offer from some other things. Now, we have something called invitation to treat. Invitation to treat is different from offer. Now, I want to give you an example. When you go to a shop or you go to a grocery store, like let's assume this Boku, or you went to ShopRite. The way those goods are displayed on their shelf, that is not an offer. That is just an invitation to treat. They're just inviting you to come and see what they are selling. So if, that's why some people will say they go sightseeing, and I love that so much. I can just, at my leisure, whenever I want to have, just go out, and try to just see things. Some people can go into these big supermarkets and come out without buying anything. Nobody would hold them because those things that are displayed, even when you go out to market, to the big other local markets, those things are just displayed. They are different from an offer. An offer hasn't been made. So who can tell me when an offer is made in cases of supermarkets? You went to a supermarket to Boku or you went to ShopRite. At what time would you say, at what point would you say offer has been made? At what point would you say, no, I shouldn't talk to acceptance now. Acceptance will visit that later. But at what time would you say an offer is made? And who makes the offer? I can't see anybody who is giving us response. Okay, when the staff walks up to you and asks if no, that is not when an offer. Price tags, no, that's not an offer. When you want to buy when you pick up the goods into the carts, an offer, even if you have picked goods into the offer, when the customer goes ahead to tender the goods and picks the cashier, yes, I hope this person that gave me that response didn't get it online. You know, it's not as if I don't trust you guys, okay? But we are in the age where the fingers are so fast online. I want you to be here with me. Do not go online to search for responses, okay? Now, someone said when you pick it from the display, from the shelf, and put them in your cart, at that point, offer has not been made. Offer is made when you take the items to the cashier, when you give it to the cashier to pack it up for you. In the process, at that point, you have put everything on the cashier desk to start doing the calculation. You know, then after you have done the calculation and told you the price, that is acceptance. And then you then make the consideration. No, after payment has not been made, is not an offer. Offer is when you take the product to the cashier's table for calculation. At that point, it means you are serious. Okay? Okay. So before payment is made at all, is offer. Okay? When you take the items today. And so that is it for display goods. Also, in the place of auctions, remember what we mean by auction is the situation where, you know, you go to, people are invited, that maybe some people have some things they want to sell. And a lot of times when it comes to auction, they sell things at very reduced price. So they will call a lot of people who are interested in that same thing. They will call them all together so that they can have a higher bid on all of that, you know. So that is it for auction. At the point where they gave the invitation that the invitation to come is not an offer, it's just an invitation to trade. And in fact, at the point when they now take the item, let's assume it's a phone and they pick it up. This is a phone, it's a Nokia, whatever. It is going for 50,000 naira. Who wants it? They will say the first this person got it, this person have it. At that point, offer has not been made. Offer is made when one person says, I'll pay 15 naira. Okay? The last person says it. When the last person says it, and you know, maybe the coordinator there says going one, going two, going three, and all of that. Okay, that is, so offer is quite different from when an auction sales are being made, okay? We also mentioned that it's quite different from tender too. And who can tell us what tender is? I'm not slow, but I think I should be faster than this because who can tell us when tenders are made? What is tender? Do not type it somewhere to come and give it to me. I will know. So this, no. Like Jumia Black Markets. What is tender? What is tender? This is not tender. Anyone that comes after it, that means they don't know it. Yeah, to submit a bid. Obi Noah said to submit a bid. You know, there are times some company will say they want some people, they need people to supply them some things. So they will say, if you would supply us toiletry, we need to send us a bid. When you send that bid, that is called a tender. When you do that, you know, that is not an offer. It becomes an offer when they tell you back that, oh, this is okay. Sorry, when they pick the people, the person they want to buy from, at that point, offers are taking place. And they pick a person, offer is taking place, the person accepts and they make payments. Okay, so also in the place of timetable and passenger tickets at the rail station, at that point, so it is called, it's not an offer, The next one is acceptance. So in a real contract, the things that takes place in a for there to be a contract, the certain elements of contract. Who is this person now? Is it a lady or who? Can you please remove this? Please. Okay, so to start with, acceptance is the final and unqualified expression of assent to the terms of an offer. Okay, so acceptance is after the offer is made, when the person whom the offer is made to accept it, assent to the offer, saying, oh yes, it's fine, I'll go for it. And so I'm going to give you an example. You went to buy a bag. You picked a bag and you keep pricing back and forth. Okay? Your last price that the other person agrees to. The first offer could be that they said, oh, the owner of the business tells you this bag costs 15 naira. That is an offer. In a lot of cases, for young people like you don't really price much. So you could say, oh, 50,000 naira, it's fine, bring it. So when they said it is 50,000 naira, at that point, the offer is made. When you say, oh, you can wrap it up for me, that is acceptance. That I assent to it, I assent to that 50,000 naira, that is an acceptance. Okay? So, but there are some times that is not as simple as I just said it. So there are some times that after, for people like us, we price. You can't just give me a bag of 50,000 naira and I'll just, it's not a supermarket where the price tags and everything are there. I go to Tejo show markets, At that point, for a lot of times, I would also give them a counter offer. If they say 50,000 naira, I can say, oh, can you take 20,000? Can you take 10,000? At that point, that's the counter offer. All right. So that is like you making a fresh offer until the other person, the owner, agrees. So acceptance can be in any way. Acceptance can shift. Initially acceptance was with the purchaser, but immediately a counter offer is made, acceptance can shift to the vendor. All right. So that's it for acceptance. So until yes, Abiba, like negotiating, that is a counter offer. When negotiating takes place, that's called counter offer. You are still doing offering and offer and offer. And so if I say 50,000, so the vendor says 50,000 naira. If the vendor says 50,000 naira and I reply by saying, no, I want to pay 20,000 naira. At that point, that 50,000 naira is off the table, right? I have made a counter offer, and the counter offer seems to be the new offer. So the next one says, until acceptance, there is nothing like revocation. Until acceptance, until acceptance, there's nothing but a revocation offer which binds nobody. So there are times that an offer is made to a vendor, or like somebody makes an offer to another person. The person whom the offer is made to can decide to revoke it, can decide to say, no, I'm not going ahead, I'm not interested. All right. At that point, parties goes their separate way. Okay. But then if after the offer was made, then the purchaser accepts it, that becomes acceptance. Okay, that would be acceptable. So after acceptance, there may exist a completed contract. Now, underline the may. So the may is there because a contract is not complete with just those two elements. And the two elements that I'm talking about is you cannot say a contract is completed with offer and acceptance. You can't just go to a shop. I'll use Tejo because it's closer to us. You can't just go to Tejo market and ask to buy bags from them. You make the offer, or they make the offer and you accept, and you decide to pick the bag and you go. What should be the next thing that would come in? After an offer is made, acceptance is taken, then what should come in after that? Payment. Thank you very much. Thank you. Payment. And in law, we don't call it payment. We have our legal term for it. Yes, it's consideration. Imole ayo, it is consideration. All right. So those three elements, they are like three plates, you know, that's under that, whose mother is the contract. So until those three are there, we cannot call it a contract. But there are exceptions. In the place of gift, there may be no consideration. All right, there may be no consideration. So before I move to consideration, I want us to consider the mode in which acceptance can take place. Modes of acceptance. So acceptance may take the form of spoken word, written words, and it can be by implied terms or by conduct. Who can give me an example of how an acceptance can be by conduct? Who can give me an example of how an acceptance can be by conduct? Okay, I'm not seeing anybody. All right. That means we don't know what conduct means. By action, yes. Yeah. Giving the cashier your card, yes, that's also, yeah. You don't really have to talk. Conduct means going by, no, it's not by the rules. Abiba, conduct is not by the rules. Conduct means by action. By doing some signs, you know, like you went to like, please accept, allow me to use Tejo market. You went to Tejo market, you went there, you just picked a bag. You didn't even say anything, just picked, and the guy from the shop was shouting, it is 50,000 naira. It is 50,000 naira. You can do like this, you know, and give them your card. You don't really have to say anything. At times, action alone can be taken as acceptance. Okay? So, acceptance must meet offer. All right? So the offer must be such that, or would I say, the acceptance should not be more than the offer they are giving you. Okay, it must meet the offer. It must not be halfway. Now they are offering to sell a bag. You cannot be expecting to see more than a bag. You know, it must meet If you're accepting, you don't accept to more than what is offered to you or less, you know, it must meet what they have offered to you. Okay, so the next is conditional acceptance. Who can give me a situation where we can have conditional acceptance? I know I'm taking much time, but I just want you to get these things. I'm doing my best to let you get these things. Okay, so I'm not saying conditional acceptance. Someone said higher purchase. No, please be careful based on the importance. No. So conditional means that acceptance under duress, no. After sales service. Yes, there could be something after sales services, yes. So, but totally, someone said by installments. No, that is when we talk about when we are talking about contract being executed and executory. But when you are talking about conditional acceptance, that means you make an acceptance. You accepted an offer based on a condition. Okay? So, for example, someone decides to buy a bag. You went to Tejo Show Market to buy a bag. When you buy, but what you noticed when you saw the bag was that the zip was not working well. The zip was not working fine. So you can actually, at that point, you know, it happens a lot when you go to Tejo Show Market, especially when you are buying used items, and maybe the zip is not working fine. You could say, but I like it so much, but this zip is not fine. So they can tell you that there could be a condition to it that, don't worry, I'll give it to the tailor over there to quickly amend it for me. Now, if they don't amend it, even if you are told the man that, oh, I'm buying it, it's okay, I'm buying it, and maybe you went out to go and do some other things, but you came back, they have not done it, or that is even telling you that, but you have taken it, you know, there are times, and you have to be careful not to give such a person your money. Because if you give him, he can decide to say, but no, you have taken it and no. So the condition there is that until it works on the zip, you will not take it. So that is it for conditional acceptance. Please, I'm coming. Okay. Okay, someone is saying something about cable provider, e.g. DSTV, who after free installation of this, I didn't see that. They will say that. So anyway, you get what I mean by conditional, so that we can quickly move this the 44 slide, which we are not anywhere. So how can acceptance be communicated? So an acceptance has no effect unless and until you have communicated it. So if it's not communicated, you cannot assume that the other person will be thinking for you. Okay? So that's why we say it must be communicated. And in the place of it being communicated, the communication can be oral. Also, where the offeree merely decides in his mind to accept but did not communicate his intention, like I said, the offeror cannot infer. And I hope at this time, I think when we're discussing offer, I should have tried to tell you the terms that we use for parties in contract. We have offeror, we have offeree. So the offeror is the person that made the offer. The offeree is the person who receives the offer and who is entitled to accept. Okay, who is expected to accept. Okay. What then are the exceptions in the place of communication? Exception to the rule of communication. Now, when we are talking about acceptance by post, before now, we don't have telephones at some time. At some points, there was no telephone. What they do is mostly commercial transaction takes place by letter. I can still remember vividly that I lost my dad some years back, and while we're going through his things to arrange things, I saw his correspondence with a company that he has worked with, not within Nigeria, they are outside Nigeria, and all of their correspondence were through post. Okay, were through post. I don't understand. This one said letter. Serious? Yes, now, don't you know that's how it has been? It was before. Like I will just say that, my dad, and it could be up to 3 months before you receive some. I'm thinking, though, I wasn't there then, but I'm thinking that it takes a lot of time before you receive some messages. So the rule of acceptance by post, it says that if acceptance is to be made by post, the acceptance is deemed as being received by the offeror the day that the offeree drops the letter of acceptance at the post office. Now, the implication is that it is not that same day that the offeree drops the acceptance letter that the offeror will receive it. But the rule then was that immediately it drops the letter at the post office, it is assumed by law that the other party has been communicated to. All right. So invariably, what it means is that they may not even have received the communication, but then the law assumes. So those are the exceptions. Also in the place of waiver. Waiver means that, let's say, for example, so a person makes an offer, and the person who had accepted the offer at some point went to sleep, went out, went for years, or went for months, and didn't say anything about it again, didn't make consideration. And then after some time, it just came again. At that point, that would have been seen as you waiving your rights. I mean, the offeree waiving their rights. Okay, so like we said here, the general rule is that postal acceptance takes effect when the letter of acceptance is posted. At that moment, the contract comes into being, although the offeror may be unaware of the existence until he actually receives the letter. At this point, I hope we are communicating. I need your response. I hope we are together. I know I'm taking too much time. I wish I can be faster. I will do my best, all right? And that's why I expect you, if you have been reading your books before you come to class, these things will be very easy for me, Okay, then I want us to look at how can an offer be terminated. There are 5 ways by which an offer can be terminated. Number 1, by revocation. Okay? You can decide to revoke. All right? Parties coming together saying, oh, we are not going ahead. Next one is by lapse of time. If there's an agreed time for which the other person is meant to respond, they didn't do it as when due, then that means the offer has been terminated. By failure of condition, if there's a condition to which the offeree gives their consent, gives acceptance, then at that point, if there's a failure in the condition, that means that the offer is terminated. It can be terminated by death as well, by death of any of the party. It can also be terminated by rejection, where the person, the offeree, rejects the offer. Okay? Where the offeree rejects the offer. Then let's quickly move to consideration. I think before now, I've been trying to chip in here and there on what consideration means. And I know by now you know what consideration means. It means payment. Now, in law, payment doesn't have to be monetarily. It doesn't have to be. Someone said there's bad communication. Is it from my end? Can any other person speak to that? Is it from my end? Okay, I know it's not from my end because my internet is very strong here. Okay, so like I was saying, remember you all said it's payment and I'm saying it's consideration. So whichever way, but now you are more or less seen as, I'm seeing you as a law student now. We don't just use words or terms in law. We have our terms for everything. And what you term to be payment is consideration at our end. So if there will be consideration, consideration does not really have to be monetarily. It doesn't really have to be by money. It could be by services or anything, but that thing should not be illegal. And number two, that thing must be something that a party loses. You must lose something. Another clause when it comes to the place of consideration is that consideration does not really have to be sufficient. Ayo, if you have a question, you can ask in the chat box. Consideration does not really have to be sufficient. Now, if you see a car that ordinarily a friend of yours wants to sell a car and would ordinarily have sold the car for 5 million naira, but because you are their friend, they can't say, oh, don't worry, just bring 500,000. That doesn't mean you have not made an offer. Okay? That is still an offer because something is coming out from you. You are giving something. And so if you are giving something like that, all right, it will be seen in the eye of the law as offer, although it may not be what you are expecting, what the normal people would have expected. All right, it does not really have to be sufficient. You just have to, something have to leave. So we also call consideration a counter promise. It means a counter promise by saying that I make a promise, you also make a promise. And it could be like this. You came to my office, you want to buy a bag. You know, I gave you the bag, I'm giving you something, you are giving me money. Or you can decide we can agree that, but I saw you, the person that come to buy a bag can say, but I sell you that you sell perfume, yes. Okay, give me this perfume. But it's not that price, but that's what I want to pay. Okay, I'll give you the perfume. I'll give you the perfume for the bag. Okay? So that's it for that. Let's quickly go to the next. So the next is rules governing consideration. By now, I hope you understand all the rules, all the things that are itemized under consideration. So who can tell me one or two things that you find very interesting in what I have explained in consideration? I mentioned some things. Did you not find them interesting? The fact that not only money, good job, does not have to be sufficient, perfect. The fact that, does not, yes, can be by service, yes. Doesn't have to be sufficient. Yeah, yes. It must not be legal. It can be a mortgage. It is well, please. Consideration can take place anywhere, all right? But please, I don't want you to be confused, okay? All right, all these things are just going, they're zooming in, so I really cannot. So, and you must lose something. Good job. Something must leave you, except in the place of gifts. But in place of consideration, at least something must leave. Do you understand? Thank you very much. That means we are all together here. So, let's now talk on rules that governs consideration. Anyway, I think you should clap for yourselves, please. You have done so well. That means you are following me. And the thing behind what we are doing now is that our time is is going so much in the speed, but then I'm just trying to ensure that, please, if you are in this class, okay, and you are not getting me, I would send my email to the class rep. You can send a mail to me, and of course, you can come to my office. I'm in room 137, but I would love an email. That email I can attend to it on time. So I'm able to explain these things to you, and that's why I'm taking my time to explain it step by step, okay? So that everyone, because this is a very large class, I don't want to assume that with the fact that I'm seeing a few people responding here, so everybody understood, right? So I want you to please ensure you are asking questions. If you are not asking questions, send a mail to me, all right? So the next is rules governing consideration. Oh, funny enough, these rules are here. Oh, please, hold on, please. Excuse me, please. Okay. Sorry, please, excuse me. I'm trying to do some things here. Okay.
Someone's caption. They carry I and Charlie one day. I mean, just say me and Charlie.
Okay, I'm sorry, I'm back. Okay. So the rules that governs consideration, and I think these are the rules that you have. I didn't even know that it's here already, but then you have done so well. The first rule says consideration must have some value, but it doesn't really have to be adequate. Like I've said, consideration must move from the promise. So if there's a promise to do something, there must be consideration for that promise. So the consideration that same consideration, which can also be a counter promise, it can be a service, it can be monetary, it can be anything if it's not illegal, but you have to leave something. All right, that's consideration. Consideration may be executed and executory. I know at this point you know what these terms, you know what they mean, what they mean rather. Consideration must not be illegal. A promise to perform an existing obligation is not consideration. Who can explain this thing? A promise to perform an existing obligation is not consideration. What does this mean? Because no value was dropped, it's more of an IOU. You don't understand, Camera. It becomes an. So I need you to have, I need you to give me a scenario. If it's father and child, I owe you, I just like you. Okay, so I'm going to give you an example. For example, a teacher that was employed to teach students, telling the student that if by tomorrow you do some certain things, I'm going to make sure I teach you very well. Or if by tomorrow you give me this thing, I'm going to ensure that I teach you more. So saying they will teach you more is already an obligation that they have been given to do. So teaching you more is more or less like that doing their job. So that cannot be seen as a consideration. All right, that is not a consideration. This sounds like a conditional, it's not a conditional acceptance. Okay, Camila. So what, like I said, consideration should not be a promise to perform an existing obligation. The existing obligation in the case of the teacher is that they have been employed to teach. You cannot tell the person, oh, by tomorrow I'm going to teach you better. I'm going to, if you can give me this thing, I'm going to ensure I teach you better in our next class. That is not consideration. Teaching the person better is even what you're employed to do before. All right. So, waiver of contractual rights. A person can decide to waive their contractual rights. And if they waive their contractual rights, it means that they are no more interested in the business. And so if they are doing that, if the other person now enjoys at their expense, they cannot come up to object to that, Okay, so in the case of promissory estoppel, what promissory estoppel means is that when you make a promise, you are expected to fulfill that promise. You cannot make a promise today and tomorrow you opt out. Okay. So in the rule in Pinhead's case can be circumvented by the doctrine of promissory estoppel, where a party has waived or promised to waive his contractual rights against another, and that other party has changed his position in reliance on the waiver promise. It will be unjust to allow an action against him on the original contract to succeed. So, for example, I bought a bag and has promised to be paying instrumentally. Please listen to me. Please listen, okay, Damilola? I made a promise. Oh, no, let me say, I went to Tejo Show Market to buy a bag. After getting the bag, my agreement with the owner of the bag was that the owner of the shop was that I'm going to be paying instrumentally. So out of 10 installments, I have made 9 installments. The day I went to make the 9 installments, the guy was so happy, and he was so happy so much that was like, so you're a very good person. Don't worry, don't give me the 10th installment again. Don't bother with it again, don't worry. I've given it to you. All right, don't bother. And maybe a week or a month after, I now went to buy a bag close to his shop. I didn't go to his shop to go and purchase the bag. I bought it in another bag, in another shop that was close to his own shop. And so he saw me coming out of the shop with the bag that I bought. He was furious, and he told me, come, no. You have to pay my balance. You have to pay my balance. I thought you are a good person and all of that. What promissory estoppel, the way promissory estoppel is explaining this, or the way the law will come in, is that estoppel has caught up with him, or that the law has stopped him. The law will stop him from further asking for the money that he has told, that he has waived. Because under the law, he has waived the last installment. He cannot come back again and be asking for that installment just because somebody had done wrong, or just because they willingly want to do it. Do you understand promissory estoppel now? That means the law has stopped that person from further asking for what they have waived. So I think that is simple enough. So let us quickly go to intention to create legal relations. Intention to create legal relations. You know, over the years in law of contracts, there's always this saying, we have divergent opinion from different scholars about intention to create about all the elements of contract. Some would say that all the elements that should be in a contract should be 4, as against the 3 I've given you earlier. And the 4th one is intention to create legal relations. Okay? Some others are saying that, in all contracts, there's always, especially in commercial transaction, there's always intention to create legal relations. I cannot go and buy I cannot go to slots to buy a phone, and when I got back home, I met a stone inside. I met stone, or I met some other thing. I met a charger, or that I met something else there. That was what I got when I got home. No. All right. So some people are saying, intention, there's always an intention that when you breach the contract, I'll take you to court. But some people are saying it's not in all cases of agreements, of legal agreement, that people infer that intention to create legal relation comes in. So for example, in social engagements, and I think I've given you that example in this class, of when a parent promises their children that, let's assume, if you do your work very well, and you leave, maybe at the end of it, you had a 1st class, I'm going to buy you a car. Assuming when the student graduates, the parents are they were not as buoyant as they used to be, and they didn't buy the car. Can you sue your parents for not buying the car? All right. So with that, intention to create legal relations is not in such agreements. Although it has all the elements. There are some elements, the elements are there, but then it's not a real contract. That's why some people went ahead to say, but it's still not a contract, because we already agreed that a contract should be something that should be binding. All right. So if it is a real contract, intention is assumed. It's not something that should be pronounced. It is assumed, as against the place of offer and all of that. For offer, we say it must be expressed. It's it must be, it's either expressed or by conduct, but then it must be made. But that intention to create legal relation, it doesn't really have to be written down before people infer that there is an intention to create. I'm just giving you like a background, like a philosophical understanding of intention to create legal relations. But whether we like it or not, it is still part of the elements of a contract, of a valid commercial contract. Okay? All right. So invariably, what it means in short, what intention to create legal relation means is that when parties are involved in a contract, they always intend that if anyone breaches, the one who is a victim can sue the one who had breached to court for the law to take its recourse for him or her to get damage, to get remedies. So the legal relations means we can involve the law if any of the party defaults, or if there's a problem, we can decide to go to court. We can decide to involve the law. All right. So okay, so trying to look at the things that are the sub-head that are under intention to break. So Raji says, if it is then pronounced and coded, does it overturn its earlier status of it not being applicable to domestic? Yes, if in a domestic agreement. Anyway, I wouldn't totally say, for example, we have one we call collective agreement. Is in that place you will understand that when it is not pronounced, you cannot do anything until parties say it. So when it comes to commercial agreement, you pronounce it, you don't pronounce it. There's always intention. Because I don't know the way you're thinking, what you think in my mind. I'm thinking, I can't go to Boku and I give them money. They say they are not going to give me bread if I want to buy bread. Who does that? In fact, even before going to court, you would have, done some drama there. There's always an intention, even if you don't pronounce it. But you get to know under these subtopics I'm going to be explaining, that under one of them, even if you say it's, the parties will still be smiling. So for social and domestic agreements, your mommy, maybe we are going on holidays very soon for the Christmas holiday. And your mom tells you that, come, Sayo, I want you to be washing. Okay, you should wash my car. Okay. Okay. Let me say, I'm being careful because you guys can just start probing me. Okay, so let's give, for example, your mom says, if you wash the plates every day, I'll make sure that I give you additional meat. If you ensure if I don't have to tell you before you wash the plates, I will ensure that I give you additional meats every day. And you were doing what you expected to do. The first day, mommy did not give you additional meats. Or let's assume at that point, you now say, mommy, let us write it down. Because tomorrow now, you will now say you didn't say it. And you and mommy, you wrote it down. Mommy signed, you signed. The next day you wash the plates, mommy did not give you your meat, additional meat, for like 10 consecutive times. And you decide to sue mommy to court. What do you think? Do you think you can sue mommy to court even after you both have agreed that we go to court? Can you sue mommy to court? I think I should be getting responses by now. So why are you saying no? Why are you saying no? Because it's a social engagement. In fact, a lot of the time, this is you can't be eating and not doing something in the house. It's something, a lot of times parties do not have the intention. And let me tell you, our mothers, they are so good at that. They may even be the one that will tell you, let us sign it. Don't worry, let me sign it. In fact, their own is something else, And in the cases, what of cases of when I could remember when we were young, and people in those days, they used to give us money. Although I know now they still give, but in those days, you can't have visitors in your house and they won't give you something when they are going. And you are giving it to mommy. I have a place, the form of I have diary in my head where I'm calculating my money, just the way I'm giving to my mom. As I'm giving to her, I'm calculating. So when December comes and she tells me I cannot buy this certain shoe for me, and I think I can buy it, I say, Mommy, give me my money. She will say, which money? How my money I kept with you? And she tell me, the food you have been eating, how did you get them? And look at it, I can't even ask her, I can't sue her to court over my money. Those are social engagement. But I want you to know also that it gets to a point where social and domestic agreements will be seen to have legal backing. So I'm going to give you a certain case. There's this man. I'm giving you an example. There's this man who lives in Lagos. He has his elder brother that who lives there at Akure. So because the expenses in Lagos was too much, and the life in Lagos was rowdy for this man, a young man, he called his uncle, that uncle, please, I like to move. And uncle was saying, move if you want to move, you can come to my house. And he said, uncle, do you mean it? He said, you can come to my house. And uncle said, and he told uncle that I have to sell my house. He said, there's no problem. You can sell it. There's no problem. You can come to my house. And then he started asking them, how does your house look like now? He said, oh, come, we don't have mattresses. We don't have chairs in our sitting room. So he decided to go back there. He sold his property and also went ahead to buy some chairs for uncle. But a day before they would travel, uncle's wife and the young man's wife, they were on a call or something, and so they had a fight. All right? So because of the fight and the way the young man's wife had spoken to uncle's wife, uncle was so angry. When this young man, when they got to Akure, uncle said, you can't enter my house. No, no, no. You can't enter my house. Look at the way your wife had spoken to my wife and all of that. In that case, what do you think should be the position of the court? Can that case be sued to court? Damilola said no. Biget said yes, yes. I wish I can explain from the both parties. I wish I can get explanation. Now, in that case can be sued to court. The man that left Lagos has sold his property. So where is he going to go back to? Who knows if maybe he has even done more repairs in the house of uncle. And uncle is saying, don't worry, come and take all your things. Get out of my house. That has gone beyond social. So this guy that is coming from Lagos has to leave a lot of things, has to let go of a lot of things. He has sold his property. He has bought things in uncle's house. So in that case, the law in that case decided that the case has an undertone of legal, but it is legally binding. Uncle is legally binding on his promise because that other guy has also forgo some things. He had bought things in the house of uncle and also had to let go of his house. He has let go of a lot of, he has lost, I won't say he has lost so much, but then he has done so much that it's better that they just sit down and resolve the matter that the wives may have. Someone says, yeah, it is complicated. Yeah, it is. But then I just want you to know, I have one other case, but because of my time, I should not go too much into that. So let us quickly, so that is for social. Ordinarily, social and domestic agreements are not binding, except in these kind of cases that I just explained to you. Now, if you have read the textbook I told you to go and read, you have found this case and you would have really been very amazed at the decision of the court. So the next one is commercial agreement. This I don't need to explain to you that much. So commercial agreements are like you going to the market to buy things, going to bank and all of that. And when one of the party breaches the agreements, the contract, the victim has the right to go to court because there is always a presumption of legal intention, of legality in commercial transaction. The last one here says collective agreement. So I just want to cite an example for collective agreement. I don't know if any of you had been engaged in this kind of a contract where one party when you were young, for example, primary school days, secondary school days, you were living in a house, maybe a house of a lot of flats, and one of your neighbors, their children also go to the same school that you go to. And at some point, the parents now decide to like, why are we wasting our fuel? We all go to the same school every day. We all come back. So let's do it this way. Why not let me take them in the morning, you bring them back in the evening? Someone wants to ask a question. Please, can you please keep this question for me, please? Please keep it for me. All right, keep it for me. I quickly want to see if I can finish up and go to the next. So, what I was saying. So, the agreement was then like, in the morning you take my children, I will take your children in the afternoon. And at some point, the person who was supposed to be taken in the afternoon, he has stopped taking the children. He will not go and he will just take his own children and leave the other person's children. Now, I want to ask you, do you think the person who had been doing the morning runs, do you think he should sue the man who is supposed to do the afternoon runs? If I said yes, any other person? This yes is too much for me. I'm not seeing any. So let me tell you, just the way what I'm sharing, if you look at the collective agreement in what I'm sharing, the position of the law is that when it comes to collective agreement, it is not binding. Because you guys just said it. It's just like being neighbors. And the law does not want to be involved in any relation, doesn't want to destroy. I would use that destroy. Although it may seem somehow. But then the law doesn't want to destroy relationship. And so the law would say they are not legally, this is not a legally binding agreement. It doesn't have the force of law, except if both parties, when they were doing that agreement, they sat down together and they signed papers. And they signed that in the morning, Mr. Tade takes the children. In the afternoon, Mr. Tunde takes the children. If any party defaults, there will be payment of so amount of money for the amount that the person who has gone to pick the children had paid on fuel or something. If there's an express statement like that, which talks about legal, says that the contract or the agreement is legally binding, that's better. Because the parties have both shown intention to create legal relation by drafting such papers and signing such papers and even giving those clauses. All right? So under the law, initially or generally, such an agreement is not binding. It can be binding. Now, they don't really have to even write it down. It can be orally. They can agree to it orally. All right? So, also in the cases of, there are times that it's not just that one. It could just be colleagues too. By the time you finish from school now, and those early days of your job hunting, or when you start working, at that time you may not have gotten a car for yourself, and so you have a senior you have another person in the office who has a car. You can all agree that, oh, you be riding us in your car and I would pay for the fuel. It doesn't mean it tomorrow. After buying fuel for him today, tomorrow he didn't carry you, he didn't pick you up. You cannot sue him. You can only sue him if all the parties have agreed that anyone that defaults will make payment or can sue. Did you see that this is quite different from social and domestic agreements? In social and domestic agreement, no matter how you sign, paper you sign, there's really another tone of no seriousness in it. In all commercial agreements, but Ma, you said agreement can be implied by conduct. The other person taking the kids in the morning is I said agreement doesn't mean, remember what I said? I said in this one, parties must expressly say that, please listen. The fact that I said the contract can be by conduct, in this case, it's an exception. That parties have to say it because under the law, generally, it is not so. Okay? It is not so. All right. So that's it for biggest bird. I hope you can understand me. So failure to pick them in the afternoon as agreed should be considered. No. Because the law there only see it as just collective agreement. Like this, just a relationship. Why are you just making it too serious? But then if you both, at the time you are making that, you are trying to develop that agreement, you both agree. It's Saturday if you don't carry the children in the afternoon. You give me money for carrying my children, and I'm going to sue you. You know, there are some people like that. They are just blunt like that, and they just, I know in this part of the world, things like that may not happen, but abroad, they don't see all this one. This one you are doing family, they don't do family. They will both agree and put it down in papers or orally state it. Because do you understand me? Did you see why it will not be considered except parties have agreed? Okay, so I'm trying to so the next, thank God we are graduating. So the question someone, let me see that question. Someone asked me a question earlier. Okay, Okaluzu Kamela, your question says that I would like to ask a question. In the example you gave, in situation of promissory estoppel and social domestic agreements, that the contract are made by words and one party sues the other to court, what happens if the other party lies and claims that he never said those words or enters into a contract? Now, I hope I will not be confused with your question because I'm seeing social and domestic agreement and I'm also seeing promissory estoppel. Okay, you are saying if, now remember we have agreed. Okay. Anyway, I think your question is that, what if one of the party lies that they never gave that promise or that they never agreed to it if the agreement was made by word of mouth? See, a lot of the time we used to ask or advise people to go to court. When you go to court, you see real contention. We call something cross-examination in court. When you are put under cross-examination and you have the right lawyer asking you questions, you will say what you didn't even expect to come and say. All right? So in law, when they are doing trials, we have examination in chief, we have cross-examination, and we have re-examination. In the place of examination in chief, is the person who has come to court that would, okay, the party for the lawyer that will talk. But in the place of cross-examination, that lie, a good lawyer will be able to get that lie and will say the truth. And that's why you have to go to court to go and test statements. A good lawyer, when you are lying, I think in a custom, in a culture, you would always hear them say that lies and truths can never change. But lie, it will always change. Because you always want to patch here. A good lawyer will get the truth out of you, okay, Camilla? So if you sue to court, even if he lies, although I'm not saying 100% you can get the truth, but to some extent, at least 60% of the time, a good lawyer will get the truth out of a liar, okay? So let me quickly go to my to contractual terms. Okay, so for contractual terms, this is my colleague. His name is Dr. Isa. I'm sure he has taught you before. Management Sciences. All right. Is it that he has taught you or he will be teaching you soon? Okay. So for contractual terms, when parties contract, please listen. But before I read this, let me try to calm down and explain this. Contractual terms means those things that parties agreed to when they were entering into a contract, when they were drafting their contractual terms. You know, all these promises, all these obligations that they have both agreed, they are both mentioned at the point of contracting. Those things are called terms of agreements. That means the things that you agreed to do. Those things are very important in law that, in fact, and you know, I think when I was explaining what contract means, I said that parties make their own laws. Parties are the ones that make their laws. And you make your laws through these contractual terms. So let me just read this out. When parties contract, they exchange promises, and certain rights and obligation arises out of the exchange of the promises. These rights and obligations are the terms, all right? Certain rights and obligation comes up. For example, I'm going to be paying instrumentally. I'll be paying every month. That is a term of contract. Oh, I'm going to ensure that I give you this car, and in the next 6 months, I will ensure that I keep checking it. Okay? Those ones are terms of contract. And so these rights and obligations are the terms of the contract. The terms may be expressed and it may be implied. You can make terms of contract can be expressly, and when we mean express can be by word of mouth, orally, it can be by writing, and it can also be by implied terms. There are some profession that in their profession, there are some things that they don't really have to write in their letter, in their contract, because there are rules of professional conduct as provided for some things, which are means this invariably they are like implied terms, things that parties can imply into their contract. Okay? Things that parties can imply. Okay, and remember what we mean by implied terms. They are not specified, but they are implied. They are things that in a trade. I think it was in this class that I mentioned the fact that when I was young, I was selling oranges with my sister. And that when we go to buy these oranges, we go to the farmers, we go to the farmer market. And at the farmer market, when you are buying, after you have bought a set, I'm thinking a set of orange then used to be 100 in a basket. After you have bought the one you want to buy, you have to pay for owo ile. It's a custom. They are implied terms. When you come to a woman and say, I want to buy oranges, how much are these sizes? And the person can tell you 10,000 naira, you select and all of that. At the point of negotiation, they won't tell you that you pay wholly because these are implied terms. If after, I think it was this same class that I told you that we went on a conference, and when we were coming, we got to a farmer's market, and we bought a lot of things. A lot of things, thousands of naira. And this man, when we're going, they refused us going. They said we have to pay 500 naira owole. And we're telling them, we were like, after buying all these things, how can you tell us we are going to pay owole? no, we are not paying. We got angry. And we said, give us money, give us our money back. They were ready to give us our money for 500 naira. They were ready. So at the point when we were buying it, I'd even forgotten about the farmer markets I used to go. He was a land law lecturer that was together with us that told us that don't forget their customs. These are implied terms by customs. And we just remembered and we paid their money and we left. Okay? So those are implied. I hope you understand what I mean by implied terms now. All right. So okay, I think I'd even explain here. Implied terms may arise by custom and practices. I think I explained that, where a term is implied by statute. It could even be law that gives some things that in this kind of environment, when you are doing anything in this kind of place or in this profession, these are the things you must do, these are the things you may not do. If it is implied by statutes, a lot of the times parties don't write it down again. Parties just assume that everybody knows the terms of the contract. There are some terms that are implied by the court too. Now, when you go to court to go and resolve your issues, there are times that the court can also imply some terms that maybe this is what the parties means by saying this. Okay, so the law can also infer some terms and put it in. Even okay, so I'm trying to see. Let me see what is here to know if I put it, if it's here already. Okay. I'm trying to be careful not to. So, for example, you have a case in court and you have issue as to the meaning of a certain word in the terms of contract. A lot of the times, it is now the court that will now help you, the both party, to think. Because, Yoruba people will say, "Ìgbà tíjà wá dé, orin wá dòwe." At times, when people are engaged into riffs, they don't seem to think very well, or they don't seem to see clearly again. Because they were friends before. The judge will try to think of when things was okay. And say, assuming things was okay between me and this person, what would I have inferred from these terms? So the court can infer terms of what they think that the party assume when they are doing some things, when they are giving some condition, when they are promising some things. Okay? I hope you understand that, my explanation. Please. Okay. So let me see this. Conditions and warranties. Okay, let me try to just close this up so we can go. This is our last slide for today. So in the case of conditions and warranties, whether express or implied, some contractual terms are more important than the other. Terms thus traditionally classified into conditions and warranties. Conditions are they are terms that are most important, and they are more important than warranties. Okay? A condition is a term which is the parties regarded as essential or so important that the breach may entitle the innocent party to repudiate the contract or claim damages. And so I'll give you an example of the condition. Remember when we were talking about consideration? No, when we were talking about acceptance, I mentioned the fact that a person went to Tejo Market, bought a cloth, but then the zip was bad. And the seller promised that quickly, you pay the money, you see that I'll do it. And after making payments, he refused to do the zip. Those are conditions for which he made that payment. If not that the vendor had promised to work on the zip, he may not have made that payment. So what the law is saying here is that I can decide, the purchaser can decide to repudiate, can decide to say, please give me my money, I'm not buying again. Or in the case of these large claims, you can sue the person who has failed in fulfilling the condition. You can sue them to court. A warranty, on the other hand, please, do you understand condition? Do you understand why it is extremely important? Conditions are those things that without which you wouldn't have entered into the contract, without which you wouldn't have been involved in the contract. Okay? So the next one is on warranty. Warranty, on the other hand, is subsidiary or a minor term, the breach of which entitles the innocent party to claim damages, but does not give him the right to repudiate the contract. So I'll give an example. I could remember that, repudiating the contract means to go back, to say, I'm not doing again. Give me my money, take your clothes. That's repudiation. All right? Or you can claim that's for, but in the place of warranty, a lot of the times you see the case of warranties everywhere. Everywhere, a lot of the times. I could remember my phone, there was a time it was so hot and it went off. It was even giving me this sign, this alarm sign, and it went off. When it went off, I put it off. So after like 4 or 5 hours, I tried to switch on again and it came up. Then I just noticed after 3 hours, it stopped working. So I took it back to Samsung. Thank God when we bought the phone, we had registered it under Samsung Care. And so they have to repair, they changed the motherboard, according to what they said, and they changed the screen, which ordinarily, that means I'm paying like 250 or 300,000. Now, if assuming I went back to them, I now say, this phone is not working again, and I'm under warranty. Please repair. And they said they are not repairing. I cannot tell them I'm not doing the contract again. Take your phone and give me my money. I can only sue them for damages for not repairing it. Do you understand? Are we together? Okay. Okay, so thank God we now know what conditions are, we know what warranties are. So exception, exclusions, or limitation clauses when it comes to contracts. In contract, we have exception clauses, we have exclusion clauses, and we have limitation clauses. Under the law, generally, the law frowns at them, especially the ones that are not done legally. So let me give you an example. There are times you go to an hotel. Maybe you went for a conference and you got an hotel. And at the point of payment, you made payments, maybe a room for a night, it was 50,000 naira, you made payments. And when you got, it's a conference that could span for 3 days. And when you got to your room, you saw boldly written beside your bed, properties are at owner's risk. Those are exception clauses. The law frowns at those things because the law expects that those exceptions should have been given to me at the point of payment, not after payment. Do you understand? The law is not saying do not give exception, but exception should be with that both parties should agree to it. If you have exception, if you have something that you think that is going to be an exception that you think is what you won't do in this contract, let the other party know. Let them put them on notice, and you both agree, not later. All right. There are some that are called, and that is also an exclusion clause, excluding themselves from responsibility. There are times that you also go to car parks. At the point of entry, they won't tell you anything. You just pay. And when you park your car, they will write cars parked at owner's risk. Those are not acceptable. So Let me just try to read. Okay. Okay. So when we are talking about hold on, please. Hold on, please. Who is that? Take the phone. I'm in a class. I'm in a class. So talk to him. Can talk to him. Yeah, so I don't want to talk to him. Okay, so I'm trying to like read the last thing here. I said in the spirit of principles of freedom of contract, exclusion clauses are perfectly legitimate. Okay, please, at this point, the time is 5:49. I'm going to give you 2 minutes to write your name. I only need your matric numbers. I only need your matric numbers now in the chat box. And those that are on YouTube, please ensure you are writing your matric number in the chat box so I can have a record of them. Okay. Okay. Let me just try to put this out there. In the spirit of the principle of freedom of contract, exclusion clauses are perfectly legitimate and the courts are normally prepared to uphold their validity. There are, however, circumstances where the court will hold that such clauses are inoperative. In doing this, they will usually take into account the relative bargaining power of the parties. Okay, so there are some times that you give an exclusion clause to a party that doesn't have a better bargaining power in that relationship or in that contract. Then at that point, the courts would want to consider it being ineffective, inoperative, and these are the exceptions. In the case of documents relied on as containing notice of excluding clause, it must be contractual document, not a voucher or receipt. So I don't know if you have also seen a receipt. After you have made payment in a receipt, they will write under that receipt, they'll be writing tiny, tiny exclusion clauses, which they didn't tell you. So what the law is saying is that for you to have an exclusion clause, it must be by both parties, and the exclusion clause must be in the terms of contract. It must be in the terms of contract, and it must be written down, or even if it's not written down, parties need to have said it expressly. Not that after the other party has made consideration, then you are saying that these are my exclusion clause. The law frowns at that. So it should not be in vouchers. So the next one said notice owned. And I gave you the notices of when you go into a car park or into an hotel room. Those ones are not approved by the court. Signature affirms. In the place of affirmation, you know that where they will say somewhere that your signature affirms, agree in your signature, you agree to all the terms that we have, or all the exclusion clauses. All of that will not be acceptable in the courts. So I want us to end at this place today and call it a day. If you have a question, you can start asking your questions. Let me stop sharing. I think by now I'm going to, those now is the end. You cannot type in anything again. If you type in anything from now, 5:52, I won't take it in. Okay? I won't take it in. Ensure you are not writing anything now. Really? Okay. If you have a question, you can raise up your hand so we can.
Please, can I get the slide?
What is the name of the textbook? I sent the, okay, your class rep has sent the course outline to you. Please go and get the course outline. Okay? Go and get the course outline and read the textbooks. You know, those will work better for you. Okay, I'm coming.
Ma, we need help. Oh. This course is very hard.
Very broad. The course is very broad. Yeah.
Ma, please.